Hello, my name is Adam Birnbaum. I'm an eviction attorney here in Pierce County, Washington. I'm bringing you this video in cooperation with Pierce County Law Library. And today we're going to be discussing a 10-day notice to comply or vacate. And this is a notice that you would use if you have a tenant that is not complying with the terms of their lease, any rules or regulations that are attached to the lease, or state law. Let's go ahead and take a look at the statute and we'll see what we have to work with here. So of course, as with all residential eviction actions, we're dealing with RCW 59.18.650. We're going to scroll down to section 2B. And 2B states that the tenant, a basis for eviction is when the tenant continues in possession after substantial breach of a material program requirement of subsidized housing, material term subscribed to by the tenant within the lease or rental agreement, or a tenant obligation imposed by law, other than one for monetary damages, and after the landlord had served written notice specifying the acts or omissions constituting the breach and requiring, in the alternative, that the breach be remedied or the rental agreement will end, and the breach has not been adequately remedied by the date specified in the notice, which date must be at least 10 days after service of the notice. Okay, so let's break down the statute just a little bit. All right, so first thing that comes to mind, obviously, if the tenant is breaching the terms of the lease, you're going to have a basis for issuing the notice. But it does say one for other than monetary damages. And so what used to happen in the past is, of course, now we know that on our pair vacate notices, all we can include is the rent, which is defined as rent, utilities, or monthly periodic charges. But late charges and other charges that may be allowable under the lease cannot appear on the pair vacate notice. And so what landlords would do is they would put them on the 10-day notice to comply. Well, that is no longer allowed under the statute. So if a tenant owes late charges or any other monetary charges, NSF fees, those cannot be put on any type of eviction notice, and the 10-day notice cannot be used for that purpose. 10-day notice would be used for other breaches regarding the terms of the lease. The big ones are typically unauthorized occupants, noise complaints that go beyond quiet hours, parking of additional vehicles, those types of things. So with regard to that, let's go and take a look at a sample notice. I'm going to go and pull one out for you here. Okay, and so this is a sample 10-day notice to comply or vacate. These notices have to be very, very succinct. And so let's take the example of a noise complaint. You have a tenant that is continually having parties from 2 a.m. to 4 a.m. And that's in violation of a particular lease term or rule and regulation that provides for quiet time between 10 p.m. and 6 a.m. So the very first thing you need to do is you need to indicate on the notice when they have to cure their violations by. So this is new to this revision of the statute. In the past, you just give 10 days notice, and the presumption was 10 days from the service of the notice. That is no longer the case. So now you have to give a compliance date, which is at least 10 days out from service of the notice. So that would go here. And again, it's at least 10 days. So I always tell my clients, don't make it 10 days exactly. Give yourself a few extra days to allow for posting and mailing if that's where you're going to serve, or you never know what happens if on the way to serve you get distracted and you've got to do something else and you end up posting the notice maybe a day or two later than anticipated. By making the actual response date maybe like 10 days, like 12 or 13 days out, it just gives you a little bit of grace time for that. All 10-day notices to comply have to have three components. The first is you have to notify the tenant specifically what lease term, rule, or law that they're breaching. So in today's digital age, there's just no excuse for not cutting and pasting the actual term. So scan the lease, and if paragraph 8 says tenants must all follow quiet hours between 10 p.m. and 6 a.m. You're going to cut and paste that portion of the lease and include it here in the first part of your notice, which basically is letting the tenant know what term of the lease or what portion of the law that they are breaching. The second portion of the notice has to let them know how it is that they're breaching that particular lease requirement or law. You have to be very succinct as well. So in our example here, where we've got parties going on all night, it's not enough to say you have parties going on all night and the neighbors are complaining. Okay, while that may factually be true, that is not sufficient enough and specific enough for the requirements of an eviction notice. So in this section here, what you would do is you'd have to put the dates and times that the noise complaints were received by your office. And so, and it's good to also indicate who it was that made the complaint. So obviously you don't need to name the actual neighboring tenant, but you can state that, you know, neighboring tenant had stated that on on September 29th at 2 a.m. they're awoken by loud music and the noise of a crowd in your unit, and the noise was loud enough to keep them from being able to go back to sleep, something to that effect. But you want to list each occurrence. So if they've had 3 parties in a week, each date, and list the times as well, and the fact that there was a complaint received by one of their neighbors. And then the last portion is you have to tell them how to cure their violation. So in this one, it'd be fairly simple. You tell them that they can cure their violation by maintaining quiet hours and not having parties or guests in their home between 10 p.m. and 6 a.m. in a manner that disturbs their neighbors. And so we have those 3 components. You've notified the tenant exactly what rule or law they have breached. You've given them specific instances as to when they breached that particular rule or law, and then you've told them how to cure. With those 3 components, you'll have an effective notice. If you're short on any of those, it's very possible that your notice will not be deemed sufficient, and you will lose that at an eviction hearing. So one other thing to indicate on your notices is there's new statutory language that provides that if your tenant has received 4 more of these violation notice in a 12-month period, that those 4 violations within the 12-month period by themselves are a separate basis for evicting the tenant. And so you want to make sure that you notify them of that. So although they may have complied with this particular notice, if they get a notice the next month because they have additional cars parked illegally that shouldn't be there, you give them notice for that. They have another breach a few months later for some other basis, and they have a 4th breach some months later, that because they've received 4 of these notices in a 12-month period, that is a basis for terminating their tenancy. But it's critical that you have this warning on your 10 days so you can take advantage of that. So again, with these lease breach notices, these 10-day notices, it's critical that you provide exacting detail. Again, cut and paste the actual lease term or law that they're violating, put that on your notice. Give dates and times for their violations. If it's an issue where they're hoarding, or there's an issue with them storing items on the premises, take pictures of that and add them as exhibits to your notice. You really want the notices to be as complete as possible. Leave nothing to the imagination. You don't want the tenant to be able to say, I didn't understand what they're talking about, or maybe they would partially comply and not do a full compliance and then have an argument that they had thought that they had fully complied. If you have a picture of the situation and you indicate in the picture, for example, everything in this photo must be cleaned up and removed, well, then it's pretty clear as to what you expect of them. And again, make sure that you tell them exactly what they need to do to cure the violation. I've seen lots of notices go out, and the first 2 components are pretty good, but then when it comes to letting the tenant know exactly what they need to do to comply, the landlord tends to forget that. Just say you've got to cure your violations, or we're going to evict you, and that isn't enough. You need to give them specific instruction on how you expect them to cure the stated violations. So if you have any further questions regarding 10-day notices to comply or vacate, feel free to contact the Pierce County Law Library staff regarding any notices, form notices that they would have available. And of course, they'll have information on how to contact me personally if you have any questions. Thank you and have a good day.